Okay, I think probably everyone's here.
Great. Well, good afternoon, everyone. My name's Simon Murphy. I'm a partner in the housing management team, and I'm joined today by Bill, who's a senior associate in the housing management team. And we're going to speak today about adverse possession. So I'm going to run through the law, and I'm going to try and do that really quickly, because normally this presentation takes about half an hour just on the law. So we're going to try and whiz through it. And then Bill is going to talk you through some practical examples so that you can apply the law to the facts, which hopefully will kind of clear up the law in your head. So we're going to try and stick to the 20-minute deadline. So I better crack on and run you through the law. Okay, so what is adverse possession? Adverse possession is the process by which a non-legal owner of land can acquire legal title to the land through adverse possession. So it's sometimes referred to as squatter's rights, and it applies to both unregistered and registered land. So in order to acquire adverse possession, firstly you have to show that you're in factual possession to make a claim. So you show that by the fact that you've dispossessed the paper owner or through abandonment, but you need to show a sufficient degree of physical control, and the control must be exclusive. So if we're talking about, for example, a strip of garden land on the external edge of your boundary, you kind of need to show that you have got factual possession of that land to the exclusion of all others. And the usual way you do that is by putting a fence up. But you don't necessarily need to do that. But if you're not putting a fence up, you need to show that you have in some way excluded all others from the land, and you've shown the outside world that you're exercising control over that land and that you're treating it as your own. If we're talking about adverse possession of a field and you're only occupying a tiny quarter of that field, possession of part is not possession of whole. So you could only go for adverse possession, you could only claim adverse possession of a quarter of the field. With factual possession, you need to show that you've been in possession of the land for the entirety of the requisite time frame, and we'll discuss what they are a bit later. So your period of factual possession can be interrupted by the paper owner. So if the legal owner comes and says, get off my land, that would stop the clock running. For unregistered land, you need to be in occupation for 12 years. So you need to show that you've been there for 12 years. You have done that with an intention to exclude others, and there has been no interruption. If you can show all of those things in unregistered land, you can obtain possessory title to the land once you have evidence of those requirements, once you've shown those to the land registry. If you're talking about unregistered land, which is going for first registration, but a squatter has been in occupation of a particular part of the unregistered land for 12 years, then at first registration, the squatter can say, no, I've already defeated the paper owner, the legal owner's title, because I've been in I've been in possession of the unregistered land for 12 years. Remember that if you're going for an application for first registration. The usual scenario is that we're talking about registered land, and in about 1998, the government decided that it wanted to stop people gaining squatters' rights to land. So it brought in the Land Registration Act, which came into force in 2002. And in that act, it said that you only had to show 10 years use of the land to apply for adverse possession, but once you'd got your 10 years, if you made your application to adverse possession, then usually the registered owner of the land would then be able to object to your application for adverse possession and would be able to clear you off from the land, provided that the legal owner did that in a year from the date that you rejected their application for adverse possession. That would defeat the claim. So the government has kind of tried to stop people from claiming adverse possession. But even under the new rules, there are 3 particular exceptions to the rule, which if you can fit yourself into one of those 3 exceptions, then you can still acquire title to adverse possession, even under the new rules which apply to registered land. In relation to any application, whether it's unregistered land or registered land, it's always useful to attempt to challenge the squatter's period of ownership. So put the squatter to proof. Challenge the assertion that the squatter has been in possession for long enough or with the requisite intention. Do some research, get some aerial photos, what's actually gone on at the site. Don't take their word for it if you are unhappy to lose title to the land. So what are those exceptions? The first one, and this is by far and away the most important one that usually people rely on, is estoppel. So the claimant's got their 10 years of use, and they make their application for adverse possession, and then they say, we also satisfy the estoppel ground, and they say it would be unconscionable for the squatter to be dispossessed because of an equity. And what do I mean by an equity? It means the registered proprietor encouraged or allowed the squatter to remain on the land. The squatter acted to their detriment in the belief that they owned the land, or it would be unconscionable for the proprietor to deny the squatter the rights that the squatter believed they had. So what we're generally looking at, what's the most common situation here where you rely on estoppel, is if you have built an extension and the extension goes over the boundary, over the legal boundary, and into land which the builder doesn't have title to. And usually in this situation, if you as the neighbour who does have title to the land, watch the extension going up, do nothing about it, watch the family move back in, watch them enjoying the extension, and then 2 or 3 years later say, oh, I've just checked my title deeds and you have built over onto my land. Usually a court would say, well, you've allowed the squatter to build on your land. They acted to their detriment in the belief that they owned the land, and it would be unconscionable for the squatter to have to take down their extension. Nearly finished, Bill, because I'm conscious that you need to get on to your examples. So the next one is relatively uncommon. So that is that the squatter has some other right to the land, and you're usually looking at incomplete purchases. So you're usually looking at the situation where somebody buys the land. For some reason, they're not registered as proprietor of the land. Maybe the land registry have raised a requisition and it's not been dealt with. They then try to sell the land to someone else who notices, and usually they get title there. So it's relatively rare, relatively uncommon. The other more common exception is condition 3. So that's where there's been a reasonable mistake on boundaries. So that's based on the general boundaries rule, which says that when you're talking about registered land, the boundary of a registered estate is not conclusive unless it's been determined. And boundary determinations are relatively uncommon. So condition 3 exists to allow a squatter to acquire title in certain circumstances where they've acted in good faith. And in order to show that, they need to satisfy 4 requirements. Firstly, they need to say that their land must be adjacent to the land that they're seeking adverse possession of. There mustn't have been a boundary determination. The squatter and any predecessor in title must have reasonably believed that they own the disputed land for at least 10 years. And the disputed land must have been registered more than 1 year before the date of the application. Okay, so that's a run through the law. Let's look with Bill at how the law applies to various different scenarios.
Thanks, Simon. Yeah, so I'm going to run through a few different scenarios. They're all masterpieces I've created on Microsoft Paint. And in each case, we are in the role of, obviously, you guys as registered providers of social housing, usually the people receiving applications rather than making them. So we are going to be owner of the red land in each scenario, and we also own the green land, but that's going to be clearly the land in dispute. And then there's a third party that owns the blue land, and they're going to be the party seeking adverse possession. So the first scenario. So we go through our checklist of what do we look at when we receive this application for, this is a first registration application. So the land is unregistered. That's the first thing to look at. The green land is unregistered. So then we have to start looking at the facts. So what has the applicant said in their application? They've sent in a statutory declaration which alleges that they've been in possession of the land for 15 years as at the date of their application. And their statutory declaration confirms that the green land, the sea land, has been fenced off by them for the full 15 years, and that they've regularly been mowing the grass. So we check our records, and there's nothing there that we can use easily to refute those allegations. So in this case, when we're looking at our checklist, unregistered land, so we're thinking, have they been in possession for 12 years? It looks like they have. They've been there for 15. Have they had the intention to possess? Well, they've fenced off the land in question, and they've been mowing the grass. So those are sort of things that, particularly the fencing, that demonstrate an intention to possess the land. So unfortunately, I think when we're reviewing this application, the evidence looks pretty strong that they have a good claim for adverse possession. So I think in this case, we'd be looking to just let them proceed with their application, or sometimes it's easier to let them know that we'd be willing to do a deal with them. And it may be that they agree to pay a little bit of money just to not have to go through the hassle of the land registry application. But unfortunately, this one looks like one where the applicant's going to be successful. So on scenario 2, very similar, but in this case, you'll see we're looking at registered land. So title was registered in 2015, title to the green land. An application has been made by the person in possession to change the register so that they become owner of the green land. Again, it's supported by a statutory declaration, which alleges that they've been in possession for 11 years at the date of the application. And again, it says green land has been fenced in for the full 11 years, and the applicant thought until recently that he actually owned the green land. Again, we check our records, and similarly, nothing there which refutes those facts. And slightly more importantly, this time we have a look at the land in question, and it's at 1.5 meters wide. So going back to our checklist, so we're looking at registered land this time. We still look at the facts. So we want to see, in the case of registered land, 10 years possession. And similarly, they still have to have an intention to possess the land. Those two things, again, look pretty covered off by their statutory declaration. They've been in possession for 11 years. They've fenced off the land. but in this case will have been invited to object to their application by the land registry. And when we do that, we can ask them to prove that they meet one of the three conditions that Simon was talking about, the paragraph 5 conditions. So estoppel, some other reason to be registered as legal owner, or mistake on boundaries. And so if we look at those three conditions, in this case, it looks possibly like they might meet the third condition, which is that they made a reasonable mistake about the location of the boundary. So looking at the requirements for that, the green land adjoins the blue land, which is the land owned by the applicant. The land in question is relatively narrow, so it could come under the general boundaries rule, and it's feasible that the applicant did think that the boundary was where the fence was. They've suggested in their statutory declaration that they thought the boundary was where the fence was, which suggests that they had reasonably made a mistake about where the boundary was. And the land has been registered since 2015, so it meets that 1-year requirement. So it's not looking hopeful again for us. But what I would say is, if you're in this position and you're invited to object, it's probably worth asking the applicant to prove one of the three paragraph 5 conditions, even if it looks like they might be successful in doing so. It's going to come at very little cost to you, and it's possible that you might draw out some evidence from the applicant that's actually damaging to their case. So probably worth asking them to come back and address those conditions. But if they come back with good evidence, again, you're looking at doing a deal or letting their application continue. Okay, so on to 3. So again, we're looking at registered land, this time registered in 2000. Again, we've received an application. We are invited to object. So this application, again, is supported by a statutory declaration. It says that the applicant has been in possession for 15 years at the date of the application. And again, land has been fenced in for the full 15 years. But there's some additional flavour in this statutory declaration. It goes on to say that the applicant thinks we were neglecting the sea land by letting it become overgrown, and that they therefore took the decision to fence off the land. And they proceeded to tend the trees on the sea land, the green land. Again, we've checked our records, so factually that looks correct. And in this case, we see that the sea land is approximately 20 metres by 30 metres, and it borders the applicant's property. So what do we do here? Well, we are invited to object, so I think we will put the applicant to proof on one of the three paragraph 5 conditions. But if we quickly run through those, we'll see if any of those apply. So we'll start at the bottom this time. So has there been a reasonable mistake as to the location of the boundary? Bit more difficult this time for the applicant, on the basis that the land is much bigger, so it's harder for them to say, well, actually, I just thought this was where the boundary was. You're looking at 20 metres by 30 metres, so that's unlikely that it's going to have been a mistake. And similarly, if you look in their statutory declaration, you'll see that they acknowledge that we were neglecting the sea land by letting it become overgrown, which shows that the applicant knew that it was our land and that they've stepped in to take possession. So I think we can rule out condition 3, the reasonable mistake on boundaries. Similarly, condition 2 doesn't apply. There's no other reason they should be registered. So condition 1, estoppel. Do we think that we've led them to believe that the land is theirs by our actions and that they've relied on those actions? I don't think so. There's nothing we've done really to give them that belief. They've just sort of stepped in and started tending the trees. If they could prove that we had knowledge of that and that we'd consented to it in some way, then maybe their application would be a little bit stronger. But I think in this case, they're probably going to find it difficult to meet any of those 3 conditions, even though they've factually been in possession for long enough, and it looks like they had the intention to possess. So on to scenario 4. I'm conscious we're running over slightly, so I'll whiz through this one. So in this case, again, we're looking at registered land, registered in 2000. The difference here is that the the adverse possessor has an express right of way over practically all of the green land. So you'll see I've tried to represent a road coming in from the top this time and running over the green land into the blue land. They say they've been using the green land as their garden for 30 years. So they've made an application on the basis of adverse possession, but they've never spoken to us about their use of the green land until now. So again, registered land. So we're looking at objecting and making sure they can meet those three conditions, or one of those three conditions. Estoppel, are we stopped from seeking possession against them? Well, we've never spoken to them about the green land, so they may say that we've acquiesced in letting them use it as a garden, but we would say we haven't. They've just done it without our knowledge. There doesn't seem to be another reason they should be registered as legal owner, so it shouldn't be able to rely on condition 2. Condition 3, so has there been a reasonable mistake as to the location of the boundary? So we're looking at a thin area of land again. So there possibly could have been a mistake. It's adjacent to the blue land. So that ticks the other condition. The land was registered more than a year ago. But in this case, what we would say is, well, you've got an express right of way over the green land. And if you've got the benefit of a right of way and the land is registered, then the chances are the green land doesn't belong to you, because you've clearly got a right over it. So how can there be a mistake as to the location of the boundary? So I think in this case would be, again, asking them to try and prove one of those three conditions, and it looks unlikely that they'll be able to do so. So I think that the main message here is when you're reviewing applications from applicants for adverse possession, always look at the facts, so intention to possess and the relevant timings, but also, particularly in the case of registered land, think about these three conditions and whether you can get them to prove that they fall into one of those three categories. So I think that's everything from me. And I don't know whether we've received any questions while we've been speaking. No, I don't think so. So unless anyone has a question, I think that's it from us.
Thank you very much for your time today. Thank you very much, Bill, for presenting with me. If you have any questions for us, which you think of at a later stage, please do email us, and otherwise we'll see you next time. Thank you very much.
Thanks very much.
Bye.
Bye.